Page 53, calendar 133, Senate Bill number 1222, an act concerning portal-to-portal workers' compensation coverage for Public Works Department employees. There's an amendment.
Senator Kushner.
Thank you, Madam President. Madam President, I move acceptance of the Joint Committee's favorable report and passage of the bill.
The question is on passage. Will you remark?
Thank you, Madam President. This is a bill that will protect Department of Public Works employees when they are called in due to an emergency situation where they are called in, or when they've been required to work 2 consecutive mandatory overtime shifts. What it does is it provides workers' compensation coverage should there be an injury to that worker on their way to and from work. We have done, in the past several years, we have made these provisions available, workers' comp available to other certain employees who are called in under emergency circumstances, like police, fire, EMS, and last year, as recently as last year, I believe, or the year before, we did the telecommunicators, the dispatchers. And upon examination of the circumstances under which people are working, we think that it makes sense to also protect workers who are working on our roads, particularly when they are called in under very similar circumstances or required to work overtime under very similar circumstances. For that reason, I hope all of my colleagues will consider this bill and will vote in favor. Thank you.
Will you remark further? Senator Sampson.
Thank you very much, Madam President. I rise to discuss the bill that is before us, an act concerning portal-to-portal workers' compensation coverage for Public Works Department employees. It's Senate Bill 1222. This is something that's been around for the last couple of years, and I've tried in good faith in the committee process to work with the chair to try and come up with language that I think is more appropriate, because I've been sympathetic to what's attempted here, but I find that the language is still just too broad. Every time I see a version of this bill, it seems to include circumstances beyond what I think a reasonable person would suggest we should have this additional portal-to-portal coverage. I think the vast majority of people who are employed in our state don't have the benefit of having workers' compensation for the purpose of driving to and from work. And generally speaking, we include that additional coverage, portal-to-portal coverage, if you will, for people under certain circumstances, whether it's an emergency situation that they're being called into work for, or some other that is beyond the normal driving to and from work, which is kind of an expectation for all of us that we've got to get to and from work. And what this bill does is it includes 3 circumstances in which they want to include portal-to-portal coverage. The first one is when an employee is subject to emergency calls while off duty by the terms of such employee's employment. And for me, that by itself doesn't get specific enough. Simply being on call, you could be on call 365 days a year. Does that mean that you should be granted portal-to-portal coverage 365 days a year, even when you're not being called in? And the answer is no. It certainly doesn't. I think that that is a bridge too far. The second thing that's included here is it says, when responding to a direct order to appear at such employer's assignment, and then it says, under circumstances in which non-essential employees are excused from working. For me, the inclusion of those terms, under circumstances, lead to litigation. That's kind of the point, I think, is to create a situation where you have a broadening of what other people, me included, would consider to be reasonable, which is when people are actually called out. And then finally, the third reason that would grant portal-to-portal coverage under this new proposed language is following 2 or more mandatory overtime work shifts on consecutive days. The fact of the matter is that lots of people work overtime, and they have mandatory overtime or non-mandatory overtime, but they're still just going to and from work. I don't understand why that would necessitate some additional workers' compensation coverage. You know, I think what's going on here, frankly, is that the Labor Committee is once again being used as a mechanism to negotiate on behalf of the unions when they're negotiating with the state of Connecticut. I am a firm believer that collective bargaining should continue. I think that the union membership has a leadership that negotiates in good faith with the state of Connecticut the terms of their contracts with the state. But ultimately, that's where this discussion should lie. This is not something that the legislature should be enacting, because effectively it's taking sides in what should be a free negotiation. It's something we talk about a lot here, which is that the state has a tendency to take sides in lots and lots of private, between the parties kind of discussions, debates, employer-employee relationships, landlord-tenant issues. You know, generally speaking, as Americans, we trust free citizens to negotiate these things on their own and make their own negotiations. When it comes to state employees, they have a process by which they organize, join a union, pay dues, and then collectively bargain with the state for benefits. And those benefits are negotiated in good faith. Sometimes you have a situation where you have municipal employees that are negotiating with the town. And, you know, the success of that union ultimately means more or less benefits for the employees, but it also means more or less costs for the taxpayers. And that's true for the state too, which is that the more benefits that are ultimately negotiated clearly benefit those employees, and good for them when they're successful, but that means more costs for the taxpayers. My objection here is that you don't have a bill supporting collective bargaining. You don't have a bill that says this is a conversation that should happen that between the union and the state or the municipality. You don't have that at all. This bill is actually anti-collective bargaining in a way, because it is saying we're eliminating the whole collective bargaining process, doesn't matter anymore, because this Labor Committee and the majority party ultimately, when we come to the Senate chamber, is going to negotiate on behalf of the union at the expense of the executive and the taxpayers outright. And for me, that's just something that's not the way it should be. I am, again, going to repeat that I'm a firm believer that collective bargaining should exist and we should protect that right. But the fact of the matter is that should mean that our role in this chamber is to protect the right to collectively bargain and negotiate the terms. It is not to pick a side and negotiate on behalf of one side of that argument. And because I believe that this language in this bill, frankly, Madam President, just goes a little too far. I think it just goes ahead and expands the realm in which employees are going to receive benefits beyond what I think is reasonable to the average person, and well beyond what is happening in the private sector, and I would argue well beyond what's happening in most union collective bargaining negotiations. This is excessive. Again, giving portal-to-portal workers' compensation coverage when the person is simply on call, not because they're being called in, just because they're on call. Or the fact that they are responding to an order to appear to work, which are under circumstances. If you take that out and you say when people are being called in, when non-essential employees, that implies that there's an actual emergency going on, and I'm in favor of that. I would support it. But why add this other language? And then the issue of the overtime shifts, which I don't think is relevant at all. I think plenty of people work overtime. I don't think that should contribute to whether someone has expanded workers' compensation benefits. So for those reasons, Madam President, I'm going to offer an amendment to make corrections to this proposed bill. And I'm going to once again encourage my colleagues and the good chairman to see this for what it is, which is an attempt to come up with a legitimate negotiation that still goes beyond protecting collective bargaining, which I think should be the limit of our role, but to come up with something that is a reasonable compromise that says, yes, I recognize that there are some circumstances where these public works employees should get additional portal-to-portal coverage, but it's not in all the circumstances that are laid out. So through you, Madam President, I'd like to offer an amendment. It is LCO 8439. I'd ask the clerk to please call this amendment and give me leave of the chamber to summarize.
Mr. Clerk.
LCO number 8439, Senate Amendment A.
The question is on adoption. Will you remark? Senator Sampson.
Thank you very much, Madam President. Yes, this amendment, just like I just laid out, makes a few very simple changes. It incorporates Section 1 of the proposed change in the language where it says when such employee is subject to emergency calls while off duty by the terms of such employee's employment. But it says that is not enough. It says that should be required along with the requirement that they are actually responding to come into work. Because simply saying that you're on call, for me, is not a good enough reason to suggest that you should get portal-to-portal coverage, but to suggest that you are on call and you're being called in, now I think the portal-to-portal coverage applies. I think that's perfectly reasonable. I think anyone listening to me who works in the real world, especially in the private sector, is going to go, yeah, that makes perfect sense, Senator. I think that that is what ought to be considered to be a friendly attempt at trying to find compromise. And then the other part of it has to do with limiting the section to remove that under circumstances, which just creates a vague situation. Certainly, I agree. If folks are being called in when non-essential employees are excused from working, that is another reason why we should grant portal-to-portal coverage, and I'm in agreement. This is the thing here. I'm in agreement in substance with what is attempted in this bill, but what they've done is draft it in a way that creates these three separate and distinct and overly broad set of circumstances. I move adoption of this amendment, Madam President. I think it's a good amendment. I think it's fair. I think it's reasonable, and I urge my colleagues to support it, and I'd like a roll call vote when the vote is taken.
The question is on adoption. Will you remark? Senator Martin.
Yes, thank you, Madam President. Just a quick question for the proponent of the amendment. So is it your understanding that the part of this underlining bill is a section regarding being on call? Your amendment would clarify that, and specifically is that the portal-to-portal workman's comp here would not apply to being on call, but only should you be called in and something happens, you would be covered. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate the question. That's exactly correct. The way the proposed bill is before us, the public works employees would be granted portal-to-portal coverage just simply for being on call. And that means they could be on call 365 days a year and nothing might happen. So they would be granted additional workers' comp coverage protection for a great period of time that the average other employee is not going to get. I don't believe in limiting them if there's a legitimate circumstance. So my amendment would say, yes, we will cover you for being on call when you're called in, and specifically when you're called in. Through you.
Thank you, Senator Martin.
Thank you, Madam President. Madam President, I have a question for the underlining proponent of the underlining bill regarding the specifics to this section that we're talking about. Does this bill, in the way that Senator Sampson is interpreting right now, are you implying, or does this bill speak to specifically to include those that are on call and they are at home and they're not necessarily en route? Through you, Madam President.
Thank you, Senator Kushner.
Yeah, let's suspend these for a moment, because I just don't know the protocol.
Senator Duff,
Thank you, Madam President. Can we stand at ease for a moment?
we can stand at ease. Will you remark further, Senator Kushner?
Thank you, Madam President. I rise in opposition to the amendment, and I do want to say that I like to follow the protocols we set up here, but I was also very anxious to answer a question that came up about the underlying bill, and I think I can do so by way of explaining why I'm in opposition to the amendment. And that is that the way this is constructed is there are different kinds of employees in Public Works who could be called in an emergency situation. Some of those employees might be subject to emergency calls. This is the reference I think the good senator is making. He's using shorthand saying on call. But what that means is an employee who has an understanding that when there's an emergency, they can be called in. In that instance, when that employee is called in, they would be covered portal to portal. Separately, there could be Department of Public Works employees who are not normally subject to being called in during emergencies. They're not what was referenced by the good senator on-call employees, but in a circumstance where a supervisor says, we need you to come in, you need to come in even though you're off duty, that person would also be covered, even if they weren't typically called in for emergencies. So I think that's the distinction that's being made in that part of the bill. And I think it's an important distinction. We wouldn't want to say because you're not normally called in for emergencies, you don't get portal to portal, but the person who is normally required to come in when there is an emergency and they're called in, they get the portal to portal. Or conversely, the person who is normally scheduled to come in and is called in on the person who is subject to be called in during an emergency gets a call in, they come in, and now they're covered portal to portal. But the person who isn't normally scheduled but still has, under these certain circumstances, they're called in, they would not receive it. So I think the intention of the underlying bill is to make sure that employees are covered in both circumstances where they're called in to work. So for that reason, I think I also want to point out this is the construct that we have for other employees that are covered by workers' comp under portal to portal, and I would not want to differ from that and create some misunderstanding because we've created two different sets of circumstances that I think should be apply equally to whether you're a telecommunicator or whether you're an employee of the Department of Public Works. Through you, thank you, Madam President.
Will you remark further, Senator Sampson?
Thank you very much, Madam President. I appreciate you giving me an opportunity to speak for a second time on the amendment that I offered. I wouldn't normally respond. I just want to make sure that we are clear about what's happening here before we take the vote. And I don't believe that the good chairman framed the amendment or the underlying bill correctly. The underlying bill says that you would be eligible for portal to portal simply by being subject to emergency calls. Whether you're on an emergency call, whether you're on vacation, whether you're on a trip to go have dinner, you would be covered. Because that's what it says. That's the only requirement, that you're subject to emergency calls. It doesn't say you're on one emergency call. My amendment says you have to actually be subject to the emergency call too. Number two says that you're responding to a direct order to appear at such employee's work assignment. And that doesn't make any stipulation that you are normally or not normally an employee that's subject to emergency calls. So I would disagree with both of those points. My amendment does the right thing by suggesting that we should be focusing on portal-to-portal coverage for people that are subject to emergency calls. Whether they are an employee that is normally subject to emergency calls is not relevant, because if they are, clearly they are subject to. And we should only be providing that coverage when they're actually called in my view. to expand this portal-to-portal coverage in cases where people are not actually being called in for purpose, to me, is a massive expansion of coverage that I don't think needs to exist. Thank you.
Thank you. Will you remark further on the amendment? Senator Martin. Remark further on the amendment. Senator Kushner.
Thank you, Madam President. Unfortunately, I don't think, I trust the good senator and his intentions. I don't think that this amendment produces the result he's intending. I think that the bill as written does require that someone who is subject to emergency calls, if you continue reading that paragraph, they are required, they don't get portal-to-portal coverage when they're on vacation and they are going to a restaurant. It is very specific. It says in the course of his employment, which is purposefully written that way because it's a term of art that is understood, and you know, I agree that it would be nice if the gender was more broadly defined, but in this case, it is a term of art, and so we want to be clear that we're using that very specifically to be related to one's employment. And it does very specifically say that you have to be leaving from your abode and going directly to duty and returning to your abode after duty. So I think that the clarity that the good senator is seeking is there. As I stated earlier, I think the intention of having 3 different conditions under which someone would be covered portal to portal relates to whether you're typically required to come in during an emergency, but you still have to be called in to get the portal to portal. You're not going to the restaurant. 2, whether you're an employee that doesn't typically get called in, but you have been because of some circumstance the employer needs you to come in. So those are that's making it clear that under both circumstances you would get portal to portal. But in no case is it covering somebody who is regular, you know, who might from time to time have to come in on an emergency, but now they're on their way to a restaurant. That is not intended here, and I don't believe that's what the bill says. So I don't think we need the amendment to get at the circumstance that the good senator is attempting to address.
Thank you. Will you remark further, Senator Sampson?
Thank you, Madam President. And again, my apologies, but we've got to clear this up because it sounds like the good senator agrees with me as to when someone should have portal-to-portal coverage, but she does not agree with my amendment, which the purpose of which is to clarify that. And I just want to make sure that we understand the language that's in the underlying bill. First and foremost, the word his in this particular paragraph is not a term of art, it's English, and it does apply to males and females. But that's besides the point. The real issue here is the fact that these different requirements separated by the Roman numerals 1, 2, and 3 are separated by a comma and then the word or. By virtue of that, that means that any one of these 3 conditions is enough to trigger the portal-to-portal coverage. That's what it means when it says reason 1, comma, reason 2, and then or reason 3. And what I'm suggesting is that by creating this 1, 2, or 3, the first requirement is simply that you're subject to being called in for emergency calls while off duty. It doesn't say that you'd have to be going to and from work. You could be anywhere. It just says that you have to be subject to emergency calls. And you could be subject to emergency calls 24/7 as a public works employee. So that means they would be receiving public work or portal-to-portal coverage every day and every moment of their employment, no matter where they are. That's what that means. And the comma to number 2 says if they meet the second requirement, that's all they would have to do. And then finally, the third thing says or. So I understand that the good chairman is suggesting that the bill says precisely what my amendment achieves, but it does not. And the amendment is necessary to create that clarity and to limit the exposure simply to what we all agree is what it should be. I urge adoption of this amendment. It's the right thing to do. Thank you, Madam President.
Thank you. Will you remark further on the amendment? We will stand at ease.
We are done with our brief recess, and we're ready to go back on the
Excellent.
record. Thank you.
Thank you. And so we are discussing an amendment, and I believe there was a request for a roll call vote on the amendment.
Madam President.
Yes.
Before we go to the roll call vote
Yes,
on
indeed.
the amendment, I do want to state for the record and for legislative intent that an employee who is subject to emergency calls while off duty by the terms of such employee's employment, that very clearly means they're not on regular duty when they're called in for a particular emergency. Those are the circumstances under which that employee would receive portal-to-portal coverage, not on a regular day of work, even though they were known to be what has been referred to here as an on-call employee. Thank you, Madam President.
Thank you. Will you remark further on the amendment? Will you remark further on the amendment? If not, I will open the voting machine. Mr. Clerk, please call the vote.
Immediate roll call vote has been ordered in the Senate. An immediate roll call vote has been ordered in the Senate. We're voting on the amendment. This is Amendment A to Senate Bill number 1222, an act concerning portal-to-portal workers' compensation coverage for public work department employees. We're voting on the amendment. This is Senate Amendment A. The Senate Bill number
Have all the senators voted? The machine is locked. Mr. Clerk, give us a tally.
Senate Amendment A for Senate Bill 1222, total number voting 36, total voting yea 11, total voting nay 25, absent not voting 0.
Amendment fails. Will you remark on the bill? Senator Sampson.
Thank you very much, Madam President. I'm disappointed that the amendment didn't pass, but I do want to express my appreciation for the chairman of the Labor Committee and the efforts that we made offline in trying to get through our differences in the interpretation of the bill language. And I want to acknowledge that I did misspeak when I mentioned that this would open up that portal-to-portal coverage for cases beyond traveling to and from work. I do, however, remain concerned about the underlying bill because it does not limit what I think is reasonable, the portal-to-portal coverage for the circumstances where someone is actually being called into work for a purpose, and it extends that portal coverage to someone that could be on call effectively 24/7, 365 on any day of the year. The fact is that most private sector employees, and I think most public sector employees, are not subject to these benefits. And I'll reiterate that this is collective bargaining via legislative vote. This bill ignores the fact that the process for making these types of decisions on benefits is the employee employment arena, where this is negotiated. We have collective bargaining for this purpose, and this bill defeats that by denying the rights of the parties to negotiate these terms and effectively making a law. And worse than that, it allows the majority to take the side of the labor argument in this particular case. I don't think that's right. I think this will lead to additional costs, particularly for municipal taxpayers. That's right, your property taxes will go up as a result of this bill, and I encourage my colleagues to vote no on it. Thank you.
Thank you. Will you remark further on the bill? Will you remark further on the bill? Senator Martin.
Yes, thank you, Madam President. I do have another question. And I agree with Senator Sampson regarding this being a collective bargaining issue with the municipalities.
Immediate roll call vote has been ordered in the Senate. We are now voting on the bill. This is Senate Bill number 1222, an act concerning portal-to-portal workers' compensation coverage for public works department employees. An immediate roll call vote in the Senate on Senate Bill number 1222. An immediate roll call vote has been ordered in the Senate. Voting on Senate Bill 1222. An immediate roll call vote in the Senate. We're voting on Senate Bill 1222. This is a vote on the bill.
Have all the senators voted? The machine is locked. Mr. Clerk, give us the tally, please.
Senate Bill 1222. Total voting 36, total voting yea 24, total voting nay 12, absent not voting 0.
Thank you.